The new law is set to be the most ambitious of all European, well, all global data protection laws, not least because of its extraterritorial approach. So when you look at the basis for the applicability of the law, you have the old provision about having an establishment in the EU and processing the data in the context of that. That's 1990 speak, is still there. And the change comes from the ability to apply the law to organizations which are not established in the EU, but that offer goods or services or monitor people, or we'll see whether we end up with monitoring people or we just sell things to people. But effectively, we can assume that those who are outside the EU that have some kind of relationship or targeting of those who are resident in the EU, like most of us here, the law will apply. And you're thinking, okay, but that's in the future. We're still in a world where we talk about terminal equipment and things like that. You would be wrong, because we have had cases, as you will all remember, where the current law, the 95 directive, has been stretched to the extremes that is not even mentioned in the draft regulation. What we have seen, of course, and this is jurisprudence right now in Europe, a year-old jurisprudence that will continue to be jurisprudence irrespective of what regime we have, because all the drafts of the regulation apply European law when the controller is established in the EU and the activities are in the context, the processing activities are in the context of that establishment. And that is exactly what the current directive says. And that is exactly what the Court of Justice of the European Union did last year. And they said, never mind that the processing is not taking place in the EU. That's 1990s thinking, where the processing takes place. Doesn't matter where the processing takes place. The important thing is the economic connection with the EU. And nobody would disagree that a company, let's say Google, to take one, has an economic connection with the EU. Like, frankly, every single organization in the world that has a website that can be accessed or used or is used from the EU. So the point is very simple. To the extent that we are thinking of perhaps avoiding the applicability of European law based on non-establishment or not use of equipment, that's gone. That's gone. The law is already applicable today, extraterritoriality.